Hello friends, Namaskar. How are you? Today I am going to discuss an important topic regarding discharge under Prevention of Corruption Act. As we know that whenever a charge sheet has been filed against us, we avail this option, and sometimes there are certain person who used to parry means avoid this option. So the primary key arises when this option has to be excised, and up to what manner it has to be excised, and what is the way in which we could excise this option in the right perspective or the important perspective to be understood by us, so that we could have an efficient results on board and our outbound results could be effective. So regarding these, the present video is quite important, and that's why each and every fact and concept are required to be noted by all of you, so that in near future when you are going to plan for a discharge petition either in High Court or in Sessions Court, in High Court means when you are in appeal or revision, so in that scenario the better way you could submit, the better way you could argue, the better way you could urge your grievances, so that you could get optimum results from the court of law. And that's why everything is important which is going to be urged here and after. I am going to discuss the judgment of Honorable Supreme Court, because we know that we are in the rule of law and everything should be supported by some judgment or by some authority or by some legislation, so that we could easily convince to the court that things are going to be happen in the unlawful manner from the side of prosecution, and we could easily get the remedy from the court of law. The reason to not have result from the court is that we used to draft in the regular manner, we are not able to submit our point in the effective manner, and that's why these are some shortcomings. Apart from that, we have to work on our case in the conceptual way, so that we could easily work out on this issue. The judgment was pronounced in a case titled as Baccaros Perfumes and Beauty Product versus CBI. The judgment has been pronounced on 6th of September 2024. In this case, the concerned appellant is basically a company, and it is the allegation of the concerned prosecution means CBI that the concerned company, its director are involved with concerned public servants, and they inter alia provided huge benefit to the concerned company, and that's why all of them by having hand in glove committed a serious crime, and that's why the concerned culprits are prosecuted as per section 420 of IPC with section 120B of IPC with section 131D of Prevention of Corruption Act. 131D is imposed because the allegation is that all of them are hand in glove, and apart from that the public servants abuse their official position to provide the undue benefit to the concerned private persons. In the present case at hand, the concerned appellant means the private limited and its director had submitted the discharge petition before the concerned trial court. The same was rejected, and ultimately they submitted the petition by the way of revision before the High Court. The same was also rejected, and finally they moved before the Honorable Supreme Court by the way of SLP. As we know that directly we could not go to Honorable Supreme Court by the way of revision or by the way of appeal or by the way of writ. Simply we have to submit the petition for SLP. Once the SLP is admitted, and then the matter is heard in the due course. So always remember that when you are going to submit the discharge petition before the concerned trial court, it is rejected, the remedy lie before the Honorable High Court, and if the Honorable High Court totally failed to intervene in the matter, then you may go to Supreme Court, but initially by the way of SLP. Then if it is admitted, then it will be heard as a regular matter. The basic allegation is that in the present case at hand, the concerned appellant is a company, and it has the conspiracy with Deputy Commissioner of Custom, and that's why the concerned official helped the concerned company and its official regarding easy custom clearance, and apart from that the goods are easily imported in the Indian market. As we know that certain fee, that is called CVD, which is usually termed as countervailing duty, is imposed, and the same is required to be imposed so that the Indian producers are not going to be affected by the imported articles. Otherwise the thing will be that the things which are going to be imported in India would be much more cheaper as compared to the Indian products, and in that scenario the Indian producers would be affected at a large. So to maintain a balance between the foreign market and the Indian market, such duties are imposed by the concerned government. But the key point is that it is imposed on the MRP, but in the present case at hand certain values are changed, in consequence of which huge loss has been caused to the concerned central government, and the loss is nearby 8 crore rupees. and the said revenue loss is termed as an economic crime, and finally the concerned CBI proceeded in the matter as per the record available. Before proceeding further, we have to understand that the concerned appellant is a private company. It is duly incorporated under the Company Act, and apart from that, it is concerned with the manufacturing and import export of cosmetic and toilet preparation. And as far as its outer body means principal unit is concerned, it is situated at a port named as Kasis. Kasis means Kandla Special Economic Zone, from where it is transferred to domestic tariff area, and finally it comes to India. But the key point is that while doing the valuation, certain manipulations are done. That is a basic allegation of the prosecution. But the key point of the concerned defense is that we deal with the product in three categories. Number one, good weighing less than 20 grams or 20 ml. Number two, the alcoholic products. And number three, the wholesale pack. Apart from that, the facts available on record suggest that the concerned officials of custom of Kandla port intervened in the matter. They found that the concerned CVD was not imposed on the MRP, and apart from that, the MRP is not disclosed effectively, which is also the violation of Standard of Weight and Measures Act 1976. And in addition to this, it violates Section 3 Subclause 2 of Custom Tariff Act and Central Excise Act. And finally, a show cause notice has been issued to the concerned appellant. As per the protocol of Section 28 of the Custom Act, Section 124 of Custom Act 1962 and Section 11A of Central Excise Act. And against the said assessment order, the concerned appellant inter alia took shelter of the concerned appellant authority of forums. In the meanwhile, CBI took up the matter and lodged the FIR as per Section 13 Subclause 1 Subclause D of Prevention of Corruption Act, and apart from that, Section 420 and 120B of IPC is imposed. The primary key of the concerned defense is that in the present case at hand, the concerned CBI totally failed or totally unable to consider the matter in reality. At the cost of repetition, I want to submit that the concerned assessment order was challenged by the concerned appellant, and their point is that the concerned protocol of CBD would be applicable when we are going to deal with the concerned goods on retail basis. When we are going to deal with the goods on wholesale basis and we are dealing in big packages, in that scenario the concept of MRP would not be applicable, and in that scenario CBD would not be applicable. To sustain the argument, they submitted the petitions to seek the clarification from the Office of Collector of Legal Metrology and Director of Consumer Affairs, and the said view was also approved by the said authority. And apart from that, they submitted the application before Settlement Commission so that they could seek the immunity from the prosecution from CE Act, CA Act and IPC. And finally, on the basis of facts and circumstances, the investigating authority of CBI submitted the closure report before the competent court. And finally, the court rejected the contention and directed that the proceeding should be initiated against the concerned appellant and the other culprits, means public servant, engaged in the matter. The consent defense had submitted the following point. Point number one, in consequence of the order from Settlement Commission, we inter alia took immunity against prosecution under CE Act, CA Act, and that's why the said order cannot be ignored by the concerned trial court itself. The point to be noted is that C means Central Excise Act and CA means Customs Act. Note the point effectively. Apart from that, the appellant and its director are not the public servant. We are the private individuals, and that's why PC Act cannot be imposed directly. Number three, CVD is applicable on MRP when you are going to deal with the goods on retail basis. It is not applicable when you are going to deal with goods on wholesome basis or the concerned packages are big, containing the different article required to be sold on retail basis in near future by certain different entities. And apart from that, all the liability assessed has been paid and inter alia documentary proof is submitted. In the case of General Officer Commandant Rashtriya Rifles versus CBI, it is submitted that mere submission of police report, which is a routine procedure, does not amount to institution of prosecution. So if after looking at the facts and circumstances and the report is submitted by the concerned police which is favoring the concerned accused, such report does not amount to prosecution, and the concerned court is bound to consider that report also. And if the court is not having or proper satisfaction with the said report, in that scenario, before discarding the same, proper reason is required to be given, which is not given in the present case. and other public servants which are involved in the present case are discharged in consequence of the fact that the sanction for prosecution as required as per section 197 of CRPC and section 19 of PC8 is not given. And apart from that, in the judgment of Hira versus CBI, same view has been retrieved. So looking to the facts and circumstances, the court submitted that when such scenarios are on record, no loss has been caused to the concerned government, there is no audit on the file. In that scenario, the concerned accused deserves the benefit and discharge accepted accordingly. So this judgment inter alia provided us the following 5 ways to contest the discharge petition whenever we are in trouble. If you are going to plan for discharge after filing of charge sheet, first we have to examine the FIR, then charge sheet and the allegation and the violations. And if they are not going to be matched properly, there is a mismatch, then we could take the benefit. But the thing is that we have to incorporate all these things in the drafting. Got the point now? Easier now? Apart from that, when we are going to submit the petition, the points are required to be much more clear. If these points are not clear, in that scenario, we may inter alia be affected by the results. Third point is that do not make your drafting or printings too much confusing. Make it much more simpler. And if there is any order by competent authority or forum in your favor, or you may also write on the previous judgment of Honorable Supreme Court and High Court of alike nature to get the benefit. Number 4, while doing the argument, just find out the violations submitted by the concerned agency. And directly we have to be pinpoint like a Arjuna. And I want to submit you, the reason is that if you are not going to pinpoint on your point, in that scenario you could not get the results in the optimal manner. And apart from that, your arguing counsel must be competent on certain points. What is your status, means you are a public servant or not, whether any immunity is there to you or not, and apart from that, whether any liability that occurred was paid by you or not. Means we have to clarify to the court that the prosecution is not only illegal, but it is also the abuse of process of law.